Greetings. Um, I am doing something I've never done before. I apologize in advance for the low technical quality of these videos. Um, I am coming to you from my home office, which is in one corner of the gracious dining room at the Walsh family homestead. Um, I have learned a lot in the last couple of weeks. I've learned how to make videos of my lectures. I've opened up a YouTube site, and I'm moving fast and furiously to try and get us ready so that we can finish out the semester over the internet and get credit for you guys for this class and keep everything rolling while the world is embroiled in chaos outside. Having said that, I'm going to be making these videos and posting them to a YouTube site that I will give to you. I'm going to try and also post them on Blackboard. I've been successful at some test runs of that. I'm going to have to break up the lectures into small segments. I found through trial and error that probably 10 to 11-minute sections upload the best and the fastest, and I really don't have the expertise at the moment to do more than that. So I'm going to have to upload these lectures in sections to you in order to get through an entire class. As time goes on, I'm sure my technical skills will evolve, and certainly if you guys have any ideas on how to assist on this, email me. I can't emphasize enough. You have to get on Blackboard and you have to start going to Blackboard regularly. I will continue to post messages and work and tests and all kinds of other stuff, handouts on Blackboard, and that's really going to be the major link that we have to communicate with each other. You can always approach me by email. I have emailed out my personal email address and my cell phone number so that any of you who need to contact me by those means can do so. But Blackboard is going to be the way in which we basically conduct the course from here on in. In addition to that, I have set up a Zoom site, and hopefully we will start on Wednesday the 25th to have our first group meeting online, but I really don't intend those to be instructional. I intend them to be more question and answer and procedural so that we can discuss what's next, where we're going, when quizzes and briefs are due, and that type of thing. So, in order to get the lectures, you're going to need to go to Blackboard, find out when I've posted things, and hopefully, as I said, I can get them on Blackboard and I can also get them up on YouTube so you can listen to the lectures at your leisure, and then we use the online sessions as a backup to ask questions and to work out details. All right, with that we begin. Handout 9 gets us into the buying and selling of real estate, and I have to say I am really not happy that I can't do this class and the next few classes with you in person, because this is my favorite part of the course. We're going to, over the next few sessions, deal with the buying and selling of real estate from both the theoretical aspect and from the actual practical aspect. And that's something that hopefully most of you will get to do at some point in your life. And I am usually very happy to have the give and take between students and myself over the processes and the ramifications and complications of buying and selling real estate. Purchase and sale of real estate is a complicated transaction. Most of us would tend to think of it in terms of buyer and seller. However, there are multiple other parties involved. Each buyer and seller usually has a real estate agent. Buyers rarely have cash in their pocket to purchase real estate interests worth hundreds of thousands of dollars. So we end up with a third party in the transaction, which is the lender who is going to give the money to the buyer. And then along the way, there are going to be other parties such as appraisers, home inspectors, and other functionaries that get involved in the process. So it is a more complicated transaction than it looks like on the surface if you've never done it before. One of the first things that we need to remember is that real estate transactions are covered by what's called the Statute of Frauds. The Statute of Frauds is a very old piece of legislation enacted by the English Parliament in 1677, and it was basically done to prevent verbal fraud from happening in the courts. Up until that time, contracts and land transactions could be testified about in court with verbal testimony and no writing. The fraud aspect of that had become so bad, Parliament finally decided we've had enough, and so they passed this law saying that any interest in land, if you want to get into court to sue the other side for something that happened or didn't happen, for some breach of contract, you must have a writing and it must be signed by that party. And if you don't have a signed document, then the court is not allowed to hear your case. As a result, all aspects of real estate transactions are conducted in writing today. And one of the basic rules you need to keep in your minds going forward as paralegals and as consumers buying real estate or selling real estate is that unless it is in writing with signatures, there's a very great likelihood that whatever you're talking about is not enforceable. All right, having said that, the statute of frauds applies here in a couple of ways. One is that certainly the basic transaction, the buying and selling of the real estate, has to be evidenced by some writing, and we'll get to that when we talk about deeds and mortgages. And then the contract to get from the ownership from seller to buyer also has to be in writing. Rhode Island, about 35 years ago, added a new element to the statute of frauds concerning real estate transactions, in that they said anyone who seeks to earn a commission, who seeks to earn money by conducting the sale of real estate for someone, by finding a buyer or a seller, has to have a written agreement stating that they are earning a commission. Without that agreement, they are not entitled to go to court to enforce any agreement saying that they're entitled to money for their services. Most folks, when it comes time to buy or sell real estate, they contact a real estate agent. In the states of Rhode Island and Massachusetts, there are two levels. One is called agent, the other is called a broker. In order to own your own independent real estate company or to hold a franchise for one of the major companies like Coldwell Banker or Remax, you have to be a broker. And these positions are licensed positions. There are exams that have to be taken. There are requirements that have to be fulfilled, reporting requirements about how money is handled, all imposed by the regulations of both states. An agent is somebody who is licensed to sell real estate, but they are considered to be at a lower level. They must operate under the supervision and control of a licensed broker. Sellers who are going to sell property, again, must sign a document, which is called a listing agreement. In that agreement, it basically sets out what the commission is going to be for the real estate agent or company that is selling your property. The agreement has to contain several things. It has to have the names of the parties, so the names of the seller and the real estate company. It has to identify the property, what real estate is being sold. It would set a purchase price, for we only know if the agent has actually accomplished their job if they have found somebody willing to buy the property at the price for which you are willing to sell. In addition, the standard real estate agreements used in Rhode Island and Massachusetts contain a couple of other provisions that consumers need to be aware of. First of all, there will be a date so that the agent will ask to be an agent for usually 180 days. A half a year is what they would like. Sometimes you can talk them down to doing 60 days or 90 days. The reason for this is they expend a lot of time and money setting up the marketing of your property, and they want a sufficient amount of time to be able to do that. I usually recommend to my clients, if they get to me at this point in the transaction, that they start off with a 90-day agreement that gives the agent time to get things set up. It also gives the client the time to figure out, the seller the time to figure out, is this working? Do I get along with this person? Do I think they're doing a good job or not? And that if 90 days come and you feel the person is doing a good job, you can always extend the agreement. Now, buyers come to the situation a little bit different format. The sellers sign up, they're going to be paying a commission, they have something in writing that they've signed saying this is my agent. Buyers, when they decide they want to start looking at properties, usually today they'll go online, and that online search will lead them to one real estate agent or another, and the agent begins showing them properties. And very often this takes several months. Sometimes for some people, if they're particularly picky or have unique needs, it might take over a year. Um, the buyers generally do not pay for the real estate services. When it comes time to the actual closing or the signing of a purchase and sales agreement, the brokers agree to split whatever commission the seller is paying between the two brokers. So very often the buyers are represented in this transaction without having to pay. In the past, that created some problems because the law was very clear. The minute the purchase and sales agreement was signed and the buyer's agent is now going to be paid by the seller, the law said they were now the agent of the seller, and they basically could not take the buyer's side in any transaction, any disagreements. This created a number of issues and caused the legislatures in Rhode Island and Massachusetts to reconsider this whole process a number of years ago, and they passed some regulations that we'll discuss in the next video.